Thus says the law. Emotions and circumstances aside, what the law says stands, even in marriage. If one married as a Ghanaian in Germany, the German Civil Code, particularly Section 1906, governed such a marriage. It provides that such a marriage prohibits polygamy, making it a criminal act, as per German Criminal Code Section 172. While gender is not important, both parties must be of the legal age of 18, have legal capacity, so as be able to give appropriate consent, and not be related by blood. The law makes cohabitation a must, as indeed parties present at the civil ceremony before a registrar. Religious ceremonies can come on after the civil ceremony. This marriage gave parties certain rights and privileges, including residency and later German citizenship. Also, a spouse, if of lesser means, had the other's state health insurance coverage, and again, his or her pension in case of death. Most importantly, it renders the one spouse the legal heir, and a surviving spouse was entitled to a compulsory portion of the deceased's estate. Suffice it to say, though, that prenuptial agreements and wills are also applicable under this marriage. Looking critically at the German Civil Code, except for the gender issue, one could think the Marriages Act of Ghana Cap 127 was being discussed. Apart from this, by virtue of international laws and practices, marriage contracted in Germany can be enforceable in Ghana. However, enforceability depends on its validity under both German and Ghanaian law. Ghana will likely recognize the marriage if it was legally performed in Germany and meets the substantive and formal requirements of both German law and Ghanaian LA. It is important to add that Ghanaian law requires registration of such a marriage to be valid. In other words, the marriage must be registered in Ghana to be enforceable there. The Registrar General's Department is responsible for the said registration. Since the two laws operate alike in both legal regimes, any other marriage is against the law and indeed criminal under the crime called bigamy in Ghana. Such a marriage is thus illegal and of no effect. None can benefit from such a relationship. It is what in Ghanaian law is called a concubinage, that is a mere cohabitation with no legal rights, especially for the woman. Had it been the case that there was a legal divorce of the marriage contracted in Germany and a customary marriage was entered into, that marriage, which in Ghanaian legal circles potentially polygamous, would have given the new wife rights under Ghana's customary law as prescribed by the Constitution of Ghana. Furthermore, if even the new wife had not contracted a customary marriage after a valid divorce and had merely cohabited with the divorced man and lived as such without formal legal arrangements, but had undergone family obligations and duties such as attending burials of the husband, had children and lived years with him, she would have been seen to be in what the law sees as constructive marriage. Under it, she could have benefits like a formally married woman at custom. There is, it seems, a thin line between concubinage and a constructive marriage setting. Appears in the latter, family recognition makes all the difference. Truth is, though love and living together can be blissful, it's always important to ensure the other party had all his or her T's crossed. Otherwise, no matter how dear the woman especially is to the man, with the law working, she may not be helped. The law is the law, and in such cases, parties involved would be told to their chagrin. Thus says the law.